Hi, I'm Annie Fitzsimmons. I'm your Washington Realtors Legal Hotline Lawyer, and this is the first video in a series entitled, You Are Practicing Law. Is it authorized? In this video series, we are going to carefully examine the Washington State Supreme Court's 1985 Cultum versus Heritage House decision. Every single one of you who is licensed to sell real estate in Washington State studied this case as part of your pre-licensing course materials. And it was probably on your examination, some aspect of Cultum versus Heritage House. So if it feels like I'm getting really deep in the weeds talking about a 1985 Supreme Court case, this is about as basic as you can get when it comes to real estate brokers having the authority to draft contracts in Washington State. If you don't know Cultum versus Heritage House, then you need to learn what we're about to talk about in this video series. In 1985, the Washington State Supreme Court made it absolutely clear that it is the practice of law anytime you select a form to use as part of a contract between two third parties. So since I'm talking to real estate brokers and you deal with the sale of real property, I'm simply going to refer to any time you draft a purchase and sale agreement. It could be a lease agreement as well. Anytime you draft that contract between two third parties, you are practicing law when all that you're doing so far is picking which forms you're going to use to prepare that purchase and sale agreement. Now you might think, well, that's pretty simple because I just use the statewide form system. I just use statewide forms. Okay, there's over 100 statewide forms. So which statewide form are you going to use in this particular transaction? And the second part of what the court said is the practice of law is the completion of those forms. So you are engaged in the practice of law when you as a real estate broker select the forms that you are then going to complete. I should use typing fingers instead of writing fingers because you're all sitting at a keyboard these days preparing the purchase and sale agreement. When you do that, you are engaged in the practice of law. And so the focus of this video series is, since you do that as an integral part of your business, are you authorized to engage in the practice of law in which you are engaging? Are you acting within the scope of authority given to you by the Washington Supreme Court when you select forms and when you complete them? And that's what we're going to examine in this video series. Because let's start with the most basic foundational principle. Unless you are a lawyer, unless you have been licensed by the Washington State Supreme Court to practice law in Washington State, you are not licensed to practice law. You have no authority to practice law. Now, how do you conform that? Because that's a true statement. How do you conform that to the concept that you are practicing law when you select forms and fill them out, and all of you do that every day as part of the provision of real estate brokerage services? How do you marry up the notion that you're not allowed to practice law unless you have a law license, you don't have a law license, and yet you are selecting and completing these forms for two third parties all the time? The only reason that you're allowed to do that is because the Washington State Supreme Court extended to you as a real estate broker in 1985 a very limited authority to engage in the practice of law. And in this video, we're going to announce what the court's standard, what the scope of that authority was, and then in subsequent videos, we're going to fully investigate every individual tenet of what the court's authority said. Here's what the court said. In fact, I'm going to read to you the language from the court's decision. Our decision provides that a real estate broker is permitted to complete simple, printed, standardized real estate forms, which forms must be approved by a lawyer, it being understood that these forms shall not be used for other than simple real estate transactions, which arise in the usual course of the broker's business, and that such forms will be used only in connection with real estate transactions actually handled by such broker as a broker, and then without charge for the simple service of completing the forms. Now, as we go through these next few episodes in this series, guaranteed there will be moments when you want to push back and say, but wait a minute, that's unreasonable. I should be able to do this or that, something broader than what I'm telling you is the scope of your authority. And when you want to tell yourself it's not fair that I'm being limited in some way, I want you to bring yourself back to where we are right now. You are not licensed to practice law, period, unless you have a law license. And if you don't have a law license, then start with a simple presumption. You're not licensed to practice law, but when you select a contract and when you complete it, you are engaged in the practice of law according to the Washington State Supreme Court, which is the sole keeper of the question regarding practice of law. Who is and who is not allowed to practice law? The Washington State Supreme Court is the only voice of authority on that question. So starting with the basic premise that you are not licensed to practice law, and yet you are engaged in the practice of law, understand that you are allowed to engage in the practice of law only within the scope of authority given to you by the Washington State Supreme Court. If you have questions on this topic or any other, please ask me a question by visiting warealtor.org. Thank you for being a Washington Realtors member.